Honorable Mohammed as co-chairpersons of the Secretariat and not the President, where the promoters cannot be accurate. First, the Secretariat emerged, as I've said, from the blues, as it were, for the first time in the process. However, Honorable Waweru himself, on behalf of himself and the co-chairperson, swore an affidavit of 5th February 2021 to state that the Building Bridges to a United Kenya was created and mandated with the task of initiating a constitutional amendment process and unifying Kenyans, among other roles. That the task force and the Secretariat conducted a robust nationwide public engagement and collection of views, and that from these views, it made various legislative, policy, and constitutional amendment proposals in various fields affecting Kenyans. So that, although the Secretariat does not disclose its origin, its ancestry, its family tree, its gene cannot be concealed. The affidavit says it all. The great-grandfather is the handshake, the grandfather is the task force, its father is the steering committee, and the surname of all of them is Building Bridges Initiative, alias BBI. The bill which the Secretariat presented together with the signatures to the IEBC was clearly, so to speak, inherited from the steering committee, almost a replica of the bill annexed to the steering committee's report to the President. The draft bill was curiously signed by Building Bridges Initiative as the promoters, and not Honorable Waweru or Honorable Junet, or even the Secretariat. It's not clear how they went about collecting the signatures, but on record, at least, there is some evidence of state involvement, going by the letter written by the Principal Secretary, State Department for Sports, directing the Director General, Sports Kenya, to supervise the staff in the organization to complete the forms and sign appropriately and urgently the forms. The conclusion I reach should be apparent on the first limb of this ground is that the President, as a matter of fact, commenced and spearheaded the process from its inception and only passed on the baton to the two co-chairpersons when it was too late in the day and beyond recall. That the President is ineligible to directly or indirectly initiate a constitutional amendment to the Constitution under any of the prescribed circumstances. That he cannot act as an ordinary citizen because he is not, and at the same time claim to be exercising executive authority. He cannot, in the circumstances of Chapter 16, run with the hare and hunt with the hounds. It has been argued that by barring the President from initiating the process of constitutional amendment, his right to equality and freedom from discrimination would be violated. The nature of violation has not been demonstrated. Looking at the facets of the rights and fundamental freedoms under Article 27, I cannot see any that could be breached by simply asking the President to stay on his lane of constitutional amendment process. Similarly, the guarantee of his political rights, which are specific under Article 38(1), that is to make political choices, to be registered as a voter, and to vote by secret ballot in any election or referenda, have not been violated. The President's role in the constitutional review process has been preserved and is intact. The power to assent to a draft bill passed by Parliament and to request the IEBC to conduct a national referendum for approval of the bill are indispensable roles and essential cogs in the process. Apart from this, the President, as indeed any other voter, is entitled to support a popular initiative by signing it, and in fact, he did so in public. Indeed, nothing stops the President from campaigning for or against the initiative. For these reasons, I agree with the learned justices that to the extent that the President took certain steps and actions at the inception of the popular initiative process, as explained, the entire process was irredeemably flawed. I would, in the result, affirm the conclusion of the Court of Appeal. The third framed issue is on the second schedule to the draft bill. The number of constituencies today, by dint of Article 89(1), stands at 290. The superior courts below were unanimous, and I am in agreement with them, that Article 89 is amendable in accordance with Chapter 16 to increase or even decrease the number of constituencies as proposed. The quarrel with the second schedule relates to paragraphs 1, 2, and 3 of the draft bill. After delimiting the constituencies for the National Assembly to 360, an additional 70 constituencies, the schedule sets out the manner and the period of review of the names and boundaries of those constituencies. This task, in terms of the Constitution, is donated to the IBC, the period being at intervals of not less than 8 years and not more than 12 years, but on condition that any review must be completed at least 12 months before a general election of members of Parliament. Furthermore, if a general election is to be held within 12 months after the completion of a review, the new boundaries cannot be used in that election. The second schedule went against Article 89 and all that I've said by providing only for a single criterion, the population quota, as the basis for delimitation. It went ahead and distributed the newly created 70 constituencies to specific counties. It directed the IBC to delimit the boundaries on the new constituencies on the single criterion. It ignored the irreducible constitutional consideration and the existing scientific criteria in Article 89. And finally, it ignored the principle of public participation. In view of the foregoing, the inescapable conclusion is that I'm in respectful agreement with the learned justices of the Court of Appeal that the second schedule to the bill was inconsistent with the Constitution, to which extent it was correctly so declared. I would reject this ground of appeal. The fourth issue is on presidential immunity. In his petition, Force 26 of 2020, Isaac Alochier versus Uhuru Muigai Kenyatta, Mr. Alochier asked the court to determine whether the president can lawfully initiate a constitutional amendment through a popular initiative process, whether the president can establish a steering committee, and whether the steering committee had locus standi to promote constitutional changes pursuant to Article 257. It also sought from the court to determine whether civil court proceedings can be instituted against the president during the tenure of office in respect of anything done or not done in excess of powers donated by the Constitution. Before us, while highlighting his submissions, Mr. Alochier complained that the two superior courts below made pronouncements that were wider than his original prayers, where he had only sought a declaration that the president had acted outside the functions of his office by unlawfully establishing the steering committee, for which he ought to have been held liable. The Court of Appeal, having arrived at the conclusion that the President was not heard in his defense on allegations of breaching Chapter 6 of the Constitution, it was moot to consider whether the President was properly sued in his personal capacity, all the orders made against him in that capacity having been set aside. Consider, too, that both courts nullified the popular initiative on the ground that the President was not qualified qua President to initiate it, confirming that his actions, the Gazette notices and so on, were official. Mr. Alochier's question was effectively answered, that no civil proceedings could be instituted against the President in his personal capacity in respect of his role in the proposed amendment. That would have been sufficient to conclude this ground. I cannot agree more that the route taken by the High Court and the Court of Appeal in responding to Mr. Alochier's contention was respectfully slightly overboard. Their determination of the matter in the manner they did has, however, presented a chance to this court to express itself directly on the question for the first time. Under Article 131 of the Constitution, the people of Kenya acknowledge the immensity and enormity of the office and declared that the President shall not hold any other state or public office except that of the President. Again, because of the exerting nature of those responsibilities, the Constitution grants the President immunity to enable him or her to discharge the functions enumerated above with as much freedom, flexibility, and peace of mind as possible. Because the President's actions while in office are actions of the state and not personal, any person who is aggrieved by the exercise of state power by the President has a recourse. First, to challenge the action in court by naming the Attorney General as a respondent in a judicial review application or a constitutional reference. Or secondly, to institute civil action at the end of the President's tenure, because Article 143.3 holds the time from running for the wrongful actions committed while in office until the President leaves office. And of course, there is the option of impeachment motion, which may be moved in Parliament against the President for engaging in gross violation of the Constitution or of the law or committing a crime under national or international law or for gross misconduct. The Court of Appeal fell into error in the manner it construed Article 143 of the Constitution, and for these reasons, I would set aside the judgment of the Court of Appeal to the extent explained. The fifth issue was the place of public participation. The twin questions before us are specific. The place of public participation under Article 10 in relation to the role of IEBC and Article 257(4) of the Constitution, and whether there was public participation generally in respect of the draft bill. Public participation today is a constitutional imperative, recognized as one of the principles of good governance and accountability. A reading of Article 257(4), the role of IEBC is to verify that the initiative is supported by at least 1 million registered voters upon receipt of the draft bill and the 1 million signatures. I've already, in the previous paragraphs, found in agreement with the two courts in respect of the delimitation of constituencies that there was no public participation. However, in respect of Article 257(4), the role of IEBC does not extend beyond verification that the initiative is supported by at least 1 million registered voters without going behind the process to inquire if the promoters did conduct public participation. It is the duty of the promoters to carry out public participation before or as they collect signatures. On their own volition and initiative, the promoters make a proposal to amend the Constitution. They must persuade 1 million Kenyans to vote in support of their venture, to convince the assemblies and parliament about the prospects of the initiative and ultimately Kenyans in a national referendum. It is the promoter's burden. Was there public participation by the promoters and later by the assemblies and parliament? According to the Secretariat, according to the steering committee, both houses of parliament, some county assemblies, Honorable Odinga, there was public participation prior to and in the course of signature collection. Whether or not there was public participation is a matter of evidence. The burden of proof is always upon him who affirms and not on the one who denies. The burden was upon those who alleged that there was no public participation to prove that assertion. Not a single person was presented to support the statement and to rebut the evidence in support of public participation. In support of public participation at the two levels, that is the promoters on the one hand, county assemblies and parliament on the other, there was sufficient evidence. For these reasons, I would set aside the determination of the Court of Appeal on the question of public participation. The sixth issue is on the composition and quorum of IEBC. And it is a common factor that IEBC was not fully constituted when the bill and the signatures were presented to it. Not fully constituted in the sense that it did not have its full complement. The vacancy started with the departure of Commissioner Akombe, who fled the country and announced her resignation while abroad on 18th October 2017, 16th April 2018. Commissioners Mwachanya, Dr. Kibiwot Kurgat, and Consolata Nkatha was the vice chair, held a press conference at which they announced their immediate resignation. By a Gazette notice of 14th April 2021, the President formally declared the 4 vacancies. The vacancies were not filled until September 2021, nearly 4 years from the date of those resignations, and 1 month after the decision of the Court of Appeal in this very matter. Article 250 of the Constitution is what may be called a provision of general application for the reason that it applies to all the Chapter 15 commissions. It declares that each commission shall consist of at least 3 members, but not more than 9. Section 5 of the IEBC Act has fixed the membership at 7, the chairperson and 6 members. For the conduct and regulation of business and affairs of IEBC, Section 8 of the Act refers to the second schedule, which at paragraph 5 provides for a quorum of 5 members. I've discussed in my main judgment the amendments in 2017 to this paragraph, how it was challenged in the case of Katiba, and the decision of Mutembei. I have also considered the effect of the decision in Isaiah Kibiwot Kangwon case, considered too the CKRC report on the management of elections, the Hansard recording the debate on the Election Laws Amendment Bill 2017. I have taken into consideration international best practices and borne in mind that IEBC is a body corporate with perpetual succession. The IEBC, whether fully constituted at 7 members or with the minimum number of 3, is responsible for the formulation of policy and strategy, as well as providing oversight. The Secretariat and supporting units, directorates, divisions, and committees, being the professional and technical arm of the IEBC, perform the day-to-day administrative functions of the Commission and implement the policies and strategies formulated by the commissioners. It is therefore a contradiction of terms for the Court of Appeal and the High Court to say in the same breath that the IBC was properly constituted with 3 commissioners but lacked quorum to transact business and conduct its affairs. I arrived at the conclusion that with 3 commissioners, the IBC was properly constituted, quorate, and competent to carry out all its constitutional and statutory duties. In the result, I would set aside the conclusion by the Court of Appeal that the IBC lacked the necessary quorum to conduct any of its business under Article 257 of the Constitution. The final framed question is on the referendum question. Whether Article 257(10) of the Constitution requires that proposed amendments to the Constitution be submitted as separate and distinct referendum questions or question was raised by Mr. Morara. Again, the details of my analysis of this issue is contained in my judgment, where I have explained in conclusion why I think the issue was premature. Noting that the draft bill had not been returned to the IBC from Parliament, IEBC had been restrained by an order of injunction from facilitating and submitting the draft bill to a referendum or taking any further action to advance it. The nature of a question or questions to be framed by the IBC was not ripe. In the end, the Court of Appeal erred in failing to set aside the determination of the High Court on this issue for violating the doctrine of ripeness. I would set aside the majority decision of the Court of Appeal to the effect that Article 257(10) of the Constitution requires the specific proposed amendments of the Constitution to be framed as question or questions. The details of what I've just rendered is in my main judgment. I thank you, Judge President.
Thank you, Justice Ouko, for rendering your opinion.